All right, now to something that was said on the Senate floor last week that generated some heated backlash, condemnation, plenty of emotion. And this was a comment made by Senator Leonard Christian, Republican from Spokane Valley. He used the R word to describe those with developmental disabilities, and he did it on purpose, not to offend anyone. He says, but knowing full well that it would bring some attention to a bill that he was hoping to put down. The bill summary here for 1390, substitute House Bill 1390. On a read from part of the bill summary, it says it eliminates the Community Protection Program and removes references to the Community Protection Program from statute effective January 1, 2027. So this basically says anyone who's in a group home setting with developmental disabilities has to be in traditional group home settings with others with developmental disabilities. The problem is those that are in the community protection program are folks that have either been accused of, charged with, convicted of some sexually violent offenses. So that was the concern that Senator Christian said, and it's why, because it wasn't getting much attention in the media, and I concede. I recall hearing about the bill. I did not pay attention to it when it was on the Senate floor last week, but because of his inflammatory comments and using the R word, which is obviously not in today's vernacular a word that's used to describe those with developmental disabilities and offensive to a lot of people. But he used it on purpose to get some attention to it. And it's worked. We're talking about it. Spokesman Review put up an article over the weekend. A lot of folks in his own caucus came out in opposition to what he said and, an official reprimand. So, anyway, I had a conversation with Senator Christian over the weekend, and here's part of that.
Is this bill really going to put these sexually violent folks in with the community that's vulnerable, who probably doesn't even know what's happening to them, doesn't quite have the ability to fight back? And my staff's like, "Yep." I said, "No, this can't be." And then to find out that the Department of Health, this was all for this, and in fact, I received a phone call asking me to support it. I'm like, "You've got to be joking me." What would you do if somebody you loved was going to be sexually, assaulted? You pull out all the stops. You do what you're sent to Olympia to do. You protect the people. And that's where I came at decided I'm going to cause a little trouble, a stir on the floor. And again, I never meant to disrespect folks. The term that we used on the floor, I mean, gosh, up until 92, the ARC used that in their name and their title. And it's still all over the internet. And it wasn't meant to be disrespectful or hurtful to anybody. It was to and get some attention from the mainstream media on how horrible this bill was going to do. And look, if you had the choice between a hurtful word and physical harm, where are you going to go?
As I mentioned, his use of the R word drew condemnation from his own party. Fellow Republicans in his district, which is the fourth district in the Spokane area, issued a letter, basically saying we don't support what he said at all. This is, not language we want used by anyone in our caucus. Um, and so Senator Christian told me he wasn't so much bothered by the condemnation. He gets the way these things work and that they probably had to come out with some sort of a statement condemning what he had said. That part didn't bother him, but he said what bothered him is that um, while they're reprimanding his verbiage, they weren't at the same time putting equal or even, an increased emphasis on how bad the bill is, in his opinion. So he's very worried about putting these, sexually violent people in with others who are vulnerable potentially to being taken advantage of. So I did write up that story. It is right now live on our page at thecentersquare.com/Washington. So you can see more of that and additional comments. And I would welcome any feedback you have as well on that article. All right, now to passage of a bill originally concerning non citizens working in law enforcement. That's how the bill was originally designed and created, and no Republicans were on board. Um, Supporters of this bill, and it's substitute Senate Bill 5068. They say that expanding job eligibility is necessary to non-citizens because we have a massive shortage of law enforcement. We're lowest per capita law enforcement numbers in the entire nation. Um, so they say that we need to open up the doors to have more people. Um, when it came over to the House, Representative Brian Burnett, who's a former Chelan County sheriff, he told the chair of the House Community Safety Committee that he sits on that committee as well at the time, I'm a firm no." He said, I think for non-citizens, we just cannot go there. This is just opening up something, you can't have, a non-citizen arresting a citizen in the United States of America." He was not okay with that. Um, but at that time, the bill was likely to sail through anyway. And so what he did is he started working on a striker amendment. And that is basically a rewrite of the entire bill. And he found a compromise that he could live with. And that basically said, okay, yeah, you can be a firefighter, you can be a deputy prosecutor, you can serve in the Department of Corrections, but you cannot, as a non citizen, work in law enforcement and have arrest powers. Um, that is the version that ended up clearing the House. It went back to the Senate, still had a lot of Republicans on that side going, "What gives, Rep Burnett? You're the former sheriff. Why the heck would you support this?" He got kind of skewered basically online, a lot of emails. He said people were not happy with him. So I had an opportunity to speak with him about his striker amendment and why he ultimately supported the bill and wants people to understand why he got on board with it.
I did not ever believe or support that we should have non-citizens being law enforcement officers that have the ability to arrest individuals that are citizens in the United States. So what happened was is I dropped an amendment that brought different language that would take commissioned police officers out of this, would not give them authority to be hired if they were non-citizens. And then even on top of that, we got some language in this and I just want to read it because this talks about the correction officers, yes, deputy prosecutors, and a couple other firefighters and stuff like that. But it specifically says verification of immigrant or citizenship status as a citizen of the United States or a person who is legally authorized to work in the United States under federal law. That is huge. So if you're not legally authorized under federal law to work here, you can't be hired for any of those other positions. But again, law enforcement officers with arrest powers are taking out of this.
Representative Burnett's legislative assistant told me this morning that she had a guy that drove from Monroe, all the way from Monroe, not a constituent of Rep. Burnett. He's Wenatchee. That's his district, but drove all the way from Monroe down to Olympia and sort of demanded to see Representative Burnett because he was so mad about this bill. And she said that, he sat down with this upset gentleman and kind of showed him what the Stryker amendment did and what the bill, how the bill reads now as it has passed. He said the guy understood, got on board, followed him on social media, thanked him for his time, and there we go. So, at any rate, it's worth a look at the amended legislation and the way it passed. So, yeah, that's going to be one that I think is going to take some time for people to understand about the bill as passed versus the bill as it was originally designed. All right, now the update on the fight over press passes for conservative journalists locked out of the wings because of their opinions, apparently. A judge heard the case in federal court on Monday. We were there, and a ruling came out Tuesday. They lost the case. The journalists lost the case. Um, Washington state lawmakers, the judge said, were within their rights to decline press passes to media figures Randy Cruz, Ari Hoffman, and Jonathan Cho. Um, you may recall it was earlier this year the Democratic controlled House of Representatives declined to issue them press credentials, and they were not really told why. Eventually found out it's because your opinion journalists And in the case of both Ari Hoffman and Brandy Cruz, they've showed up and spoken at some of the rallies in favor of the initiatives for restoration of parental rights and the protection of girls in sports. So, according to the folks that issue the credentials here in Olympia, they're too opinionated. They're not unbiased journalists. So that was the argument, and I guess the judge agreed. This isn't the end of the fight, though, by any stretch of the imagination. And today, I got an update with Citizen Action Defense Fund Executive Director Jackson Maynard on where things go from here. He was the one who made the arguments in court on Monday on behalf of these three independent conservative journalists. So here are his updated thoughts on where things go from this point.
This is just a little longer battle than we anticipated, but the battle's not over, and the war's not over, and the fight will continue for press freedom for our clients. The idea that the legislature is a non-public forum is just flies in the face of 50 years of tradition. Yeah, as we argued that day in our briefing, it's a limited public forum, and as such, members of the press are entitled to robust protection in the rights in the areas that they have traditionally been allowed to be in. I thought it was a little odd that the court acknowledged that there were problems with how the due process that was allowed, the process that the legislature used in terms of how it approved or denied the press passes, the fact that it could take days for them to approve a day pass. In fact, 3 of my clients didn't find out until 2 or 3 days later that the day that they had applied for, that they weren't eligible to have it, and they didn't have the facts necessary to know and to be able to contest those. The court said, yeah, that's problematic, but ultimately kind of brushed that aside, in my opinion. The court said that there wasn't enough evidence that the reason that my clients were excluded, Brandy and Ari, was based on their political participation. That was in the affidavit from the state defendants, where they said, "We know you're going to be speaking at a rally," and it certainly formulated the basis, and that's content-based discrimination, which under the cases we cited cannot be the reason that you don't allow a member of the press to have access.
It's also worth noting that there are some questions circulating as to involvement by the Capital Correspondents Association in all of this. The CCA, not the Commitment Act, but the Capital Correspondents Association, is made up of reporters from publications around the state who cover politics in Olympia. We are not. The Center Square is not a member of that organization. And up until last year, it was the CCA that advised who got credential access and who did not. After they tried to deny the Center Square full press credentials, we had to push the issue legally. And the CCA then bowed out and basically said, we're out of this whole credential saga. Turned that over to the House and Senate separately to make those decisions on who got access. And the House ultimately, said that those 3 members did not have access. But a spokesman review reporter and the spokesman review, a member of the Capital Correspondents Association, wrote up this whole, latest court case and the battle over that. And they conceded in their own article, which came out yesterday, that the newspaper has financially contributed to enlist the services of the attorney that represents the association in the lawsuit. So basically conceding what could be a potential conflict here, it seems. You can decide what you think about that for yourself. But to have media organizations funding the legal defense, trying to keep other media organizations from getting press passes, whether or not there's an actual conflict of interest there that needs to be addressed, that's going to be up to the courts to decide. But I thought it was worth, um, you know, bringing up that point in light of the low court loss initially that we've got here, and we'll see where that goes. We're not going to let up on it, I promise. So, insurance companies in the state of Washington may soon need to foot the bill for additional abortion funding. A proposal passed on Wednesday evening in the state legislature to require health carriers with insurance plans offered on the Washington Health Benefit Exchange to pay a tax. So this is Senate Bill 6182, and it would impose an assessment initially of 82 cents a month on coverage for each person that's enrolled in the program. It drops a little bit in the years after that. During a public hearing on this bill, it became very clear that Planned Parenthood, the organization that stands to benefit from the additional funding for abortion, was obviously very much on board with the legislation. So this is one of their advocates testifying in favor, and as you've probably heard before, blaming the Trump administration for cuts to what they call reproductive health care.
A creative revenue solution that supports abortion patients and safety net reproductive health providers. Under the ACA, health benefit exchange plan carriers are required to hold a portion of insurance premiums in a separate account for abortion care coverage, charging at least $1 per member per month. These funds far exceed the amount used for abortion care. The balance in Washington is approximately $13 million and generates another surplus of $2 million annually. But seeing an opportunity to score points with anti-abortion extremists, the Trump administration took aim, releasing an FAQ last month allowing insurance companies to absorb funding meant for abortion to their general account. Wiping out these funds violates the intent of ACA statute and diverges from how these funds have operated for over 10 years. This bill is an opportunity to right this wrong. By implementing this tax, Washington can protect funding for abortion care from abuse from the Trump administration. You will hear from many providers and organizations about the impact this funding will have for patients and community. SB 6182 rights this wrong by recouping segregated funds for their intended use, abortion care. Please pass SB 6182.
So in the first year, this tax is estimated to bring in about $10 million, and then around $2 million each year after that. That was according to a fiscal analysis attached to the legislation. And insurers who don't, collect the extra money from their enrollees would pay fines. The insurance commissioner is going to be watching this very closely. Lots of organizations opposed to this, obviously religious objections, and folks that, yes, say just because I get my my coverage through the state health benefit exchange and the Affordable Care Act, I shouldn't have to pay for, maybe they've got religious objections to abortion and don't want money to be going to Planned Parenthood. But in this legislation, they're really not going to have any choice, at least at this point. I spoke to Representative Matt Marshall of Eatonville. He's served in the U.S. Army, and he's also an orthopedic surgery physician assistant. He's kind of, they call him Dr. Marshall on campus. He tried to get an amendment on the abortion funding bill, basically arguing, well, okay, if this is actually a bill in the name of reproductive health care, then maybe we should let couples use some of this funding if they're having trouble getting pregnant, having fertility issues. So maybe you could pay for IVF treatments or that sort of a thing with some of the funding. So it can be as much pro-family as it could be, ending a life. So here's part of that conversation with Representative Marshall.
Democrats, yet again, are doubling down on abortions, trying to make it an issue going into the elections this November. Now, what this one does is it requires every health insurance plan in Washington to charge a fee, a tax, on every member in the state who has health insurance every single month. So I believe it's 86 cents per member per month that is going to go into a new account that's being created under this bill, and is going to fund Planned Parenthood or abortion providers only. It's incredibly troubling. My biggest concern is the fact that there's strong moral obligations or moral objections to abortion, and there's no opt-out provision here, and it is something that is required for every health insurance plan, even if it's one being provided by a religious employer or a pro-life employer. You're being forced by the state to pay into this fund with no other recourse.
The measure ended up clearing the House late on Wednesday, and it was a party line vote with no Republicans in support. Now, I should also note, Planned Parenthood is separately getting a lot of money in the budget. $8.6 million for a backfill to Planned Parenthood from what was cut on the federal level, and then another $10 million that they're getting in the budget, yet to be signed, will be, I'm sure, by the time you're watching this, but this is before the new abortion fund that taxpayers are going to be on the hook for through these insurance premium hikes. So I had a member on the Senate side tell me this week that Planned Parenthood is getting more money in this legislative session than they ever have in the state of Washington. So that's been a priority for the majority this year, and they made it happen in the budget. So we'll keep an eye on that one.